Welcome to SCOTUScast, Arbitration Preemption Edition. Thank you for tuning in. On October 6, 2015, the Supreme Court heard oral argument in DIRECTV v. Imburgia. This case involves a class action lawsuit which argues that DIRECTV improperly charged early termination fees to its customers. The question is whether the California Court of Appeal erred by holding that a reference to state law in an arbitration agreement governed by the Federal Arbitration Act requires the application of state law preempted by the Federal Arbitration Act. To discuss the case, we have Cory Andrews, who is Senior Litigation Counsel at the Washington Legal Foundation. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Mr. Andrews.
In domestic and international commerce, countless parties depend on the availability of arbitration to resolve disputes. Arbitration offers several advantages over litigation. Arbitration is usually faster and less adversarial than litigation, and as a result, more cost-effective as well. Under arbitration, the parties can select an arbitrator with expertise, thereby avoiding the need to educate a judge or jury on highly technical matters. Arbitration is private and confidential, and so avoids the risk that sensitive trade secrets will be disclosed, or that the parties' dirty linen will be aired in public. Perhaps the greatest attribute of arbitration is its flexibility. The parties can contract for whatever procedure, discovery practice, and evidence rules that they want. Arbitration may be binding or not, and the parties may choose to submit some or all issues to the arbitrator for resolution. So it's no surprise that with all of its many advantages, arbitration has seen historic growth and success as an alternative means of resolving disputes. In an effort to reverse long-standing judicial hostility to arbitration agreements, Congress enacted the Federal Arbitration Act. The FAA requires that all arbitration agreements be placed on equal footing with any other contract and manifests a substantive federal policy in favor of arbitration. In 2011, the Supreme Court held in AT&T Mobility v. Concepcion that California state contract law, which had for years deemed class action waivers in arbitration agreements unconscionable and therefore unenforceable, was preempted by the FAA. Such state laws, a 5-4 majority of the court concluded, impermissibly interfere with fundamental attributes of arbitration by requiring the availability of class-wide arbitration, even contrary to the parties' agreement. Reversing the Ninth Circuit, the majority in Concepcion articulated many practical and pragmatic reasons why the very notion of class-wide arbitration is simply unworkable and undermines so many of the unique advantages of arbitration in the first place. The enforceability of an arbitration agreement containing a class action waiver is once again back before the Supreme Court, this term in DIRECTV versus Imburgia. And just as in Concepcion, the focus is on California state law. Unlike Concepcion, however, DIRECTV involves an appeal directly from the California Intermediate Appeals Court, not from the Ninth Circuit. Petitioner DIRECTV is a leading broadcast satellite service provider that broadcasts licensed programming to paid subscribers. In 2007, years before Concepcion was decided, DIRECTV's standard subscriber contract contained an arbitration agreement that included a class action waiver. By that time, California had already adopted a rule that invalidated as unconscionable under California law nearly all consumer arbitration agreements containing class action waivers. This came to be known as the Discover Bank Rule, named after a 2005 decision of the California Supreme Court. In light of that ruling, DIRECTV's arbitration agreement included the following non-severability provision. Quote, if the law of your state would find this agreement to dispense with class arbitration procedures unenforceable, then this entire arbitration agreement is unenforceable. End quote. DIRECTV's subscriber contract also contained a choice of law provision, which expressly provided that the arbitration agreement must be governed by the FAA. Respondents in this case are former DIRECTV subscribers who, in 2008, filed separate putative class action lawsuits against DIRECTV in California state courts, alleging that DIRECTV violated California law by charging them an early cancellation fee when they prematurely canceled their subscriptions. Those cases were later consolidated into one proceeding in Los Angeles Superior Court. Because of the Discover Bank Rule, DIRECTV did not move to compel arbitration at the time suit was filed, but proceeded in court until 2011, when the Supreme Court held in Concepcion that California's Discover Bank rule, which again required the availability of class-wide arbitration, quote, interfered with the fundamental attributes of arbitration, end quote, and thus was preempted by the FAA. Following the court's decision in Concepcion, DIRECTV moved to compel arbitration pursuant to the subscriber contract's arbitration agreement. The Los Angeles Superior Court denied the motion, concluding that the arbitration provision was unenforceable under California law. On appeal, the California Court of Appeal affirmed. The appeals court relied on the arbitration agreement's non-severability provision, which stipulated that if the law of your state would find the class action waiver unenforceable, then the entire arbitration agreement is unenforceable. The appeals court interpreted the phrase, quote, the law of your state, end quote, to mean the non-federal law of your state without considering the preemptive effect, if any, of the FAA. In other words, the appeals court concluded that the arbitration agreement's non-severability provision required application of California law, even if that law was contrary to or preempted by federal law, and even if it was contrary to the service contract's own choice of law provision, which again provided that the arbitration agreement shall be governed by the FAA. Finding the class action waiver invalid under California law, the appeals court then refused to enforce the arbitration agreement based on the non-severability clause. When the California Supreme Court declined review, DIRECTV successfully sought certiorari from the U.S. Supreme Court on the grounds that, among other things, the appeals court's holding directly conflicts with a prior decision by the Ninth Circuit in Murphy versus DIRECTV, Inc., which interpreted the same language in the exact same arbitration agreement as requiring arbitration, and even dismissed as nonsensical the very interpretive reasoning adopted by the California Court of Appeal. DIRECTV, represented by Chris Landau of Kirkland & Ellis, argues that the arbitration agreement is straightforward and should be enforced according to its terms. The parties never would have specified that their agreement to arbitrate is governed by the FAA if they had intended to bind themselves to state law inconsistent with the FAA. As a result, the California court's tortured reading of the contract runs afoul of the FAA's mandate that state courts interpreting arbitration agreements must resolve any doubts in favor of arbitration. The respondents, represented by Tom Goldstein of Goldstein & Russell, argue that this is a case about the interpretation of private contracts, which is strictly a question of state law and ordinarily something the Supreme Court does not review. Respondents argue, therefore, that this case does not implicate the FAA, which leaves to the states the routine task of interpreting contracts under traditional common law principles of state law. But if the phrase "the law of your state" is ambiguous, respondents suggest that ambiguity should be construed against the agreement's drafter, DIRECTV, and not against the respondents. In response, DIRECTV contends that while the interpretation of private contracts is ordinarily a question of state law, which the Supreme Court does not review, that is not the end of the matter. Relying on the Supreme Court's opinion in Volt Information Sciences, DIRECTV argues that when state courts apply general principles of contract interpretation to an arbitration agreement, due regard must be given to the federal policy favoring arbitration, and any ambiguities as to the scope of the arbitration clause itself must be resolved in favor of arbitration. At oral argument on October 6th, the justices repeatedly pressed Chris Landau to articulate some standard or test for where the line should be drawn to ensure that the court isn't called on to review every application of state law that ends up invalidating an arbitration agreement. Absent some workable test, Justice Breyer even suggested the possibility of certifying the question presented to the California Supreme Court. Landau ultimately relied on the unique facts of this case as the threshold, that the holding below flouted well-accepted universal principles of contract law, including that a contract should be interpreted in a manner that makes it valid rather than invalid, that the phrase "law of your state" obviously refers to valid state law, not invalid preempted state law, and that the contract's own choice of law provision again provides that interpretation of the arbitration agreement is governed by the FAA, not by some abstract state law contrary to the FAA. For his part, Tom Goldstein did his best to reframe the question as being whether an arbitration agreement even exists in the first place, rather than the scope or enforceability of that agreement. While no one on the bench seemed especially persuaded by that line of argument, Goldstein was more persuasive when he played up the justices' fears that, If they granted relief in this case, the court would suddenly become, in Justice Breyer's words, the supervisor of all state contract interpretation judges. Goldstein cautioned the court repeatedly not to open up that can of worms. Yet nearly all justices appeared to agree that the California court's reading of the contract was indefensible, and that the appeals court had gotten it wrong. And Justice Roberts made clear his view that while, yes, the case presents a matter of state contract interpretation was precisely the evil to which the FAA was directed in the first place. Congress wanted to rein in state courts interpreting contracts under special rules hostile to arbitration. And in response to Goldstein's parade of horribles that might follow from reversal in this case, Justice Scalia offered his own horrible. If we agree with you, states can do whatever they want to invalidate arbitration agreements so long as they're doing it under the guise of contract interpretation. It is that concern, defending the integrity of and ensuring adherence to the court's precedents, which very well may determine the outcome of this case. In the absence of reversal on these egregious facts, state courts undoubtedly will feel even more emboldened to flout the court's arbitration precedents, including Concepcion itself. In any event, I would be surprised if a majority on the court is prepared to affirm the California Appeals Court's unusual interpretation. As Justice Alito suggested, the California court interpreted the contract in such a strange way that the only possible explanation for that interpretation is hostility to arbitration. If I had to venture a guess, I'd predict it is that view that will find favor with at least 5 justices when the court's decision is issued later this term.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.